Friends, in this video we are going to talk about the complaint filed by We Bankers Union under Industrial Disputes Act before the Honorable National Industrial Tribunal Mumbai as well as the Honorable Chief Labour Commissioner Central New Delhi. The complaints, of course, are against the bipartite settlement signed between the bank employees and IBA. We will see why they have filed the complaint against the bipartite settlement. We will also discuss the reason why they have sent letters to the heads of all public sector banks with regard to payment of arrears to the employees and levy to the unions. The letters were sent to the banks last week on 17th of November, 6 days after the bipartite settlement was signed between unions and IBA. In the letter, we bankers are drawing attention of the heads of the individual banks to the reference made by central government to the Industrial Tribunal Mumbai. The reference has been made because of the apprehended dispute between public sector banks and we bankers in the case of wage revision for bank employees. All the public sector banks have been made parties to the above industrial dispute, and all the public sector banks must have already received the order issued by the government also. It is settled law that the adjudication starts the moment the order for adjudication is passed by the appropriate government, and consequently the mandatory provisions of Section 33 of Industrial Disputes Act 1947 gets invoked automatically. Once it gets invoked, no change in the service conditions of the employees can be effected by the employer. This means that the settlement now signed is in clear violation of the settled laws as claimed by we bankers. The union also invites attention of the bank managements to the fact that the order for adjudication passed by central government was placed by the Additional Solicitor General of India before the Honorable Allahabad High Court on 4th November during the course of hearing in the writ petition filed by we bankers. But Indian Banks Association, who was well aware of the commencement of the adjudication process and its implications, preferred to violate the settled law and proceeded to sign the settlement with the employees on 11 November 2020. This was in spite of the communications sent to IBA and the public sector banks by we bankers on 7th and 9th of November, drawing their attention to the starting of adjudication process. The we bankers also had requested them not to violate the settled law by entering into any settlement during the pendency of the adjudication proceedings. Besides, the union had also sent a request to the Chief Labour Commissioner and also Additional Chief Labour Commissioner not to register any settlement if entered between IBA and the banks, quoting the relevant provisions in Industrial Disputes Act. Therefore, the we bankers were forced to file complaints against the parties before the National Industrial Tribunal Mumbai and Chief Labour Commissioner Delhi against what they call as utter violation of the settled law. These complaints are now pending for consideration and taking decision before both the honourable authorities. Similarly, we bankers are also challenging the competence, power and authority of the public sector banks to accede to the request made by the unions to deduct levy from the arrears paid to the employees. According to them, the Code of Discipline and criteria for determination of recognition has not been implemented in any bank. This is a code which provides the valuable right of democracy to employees to elect their representatives. As per the provisions of the code, holding position in the unions or associations is not enough to represent the bank employees, and the representatives are to be elected at branch, regional and all India level by the employees through secret vote. Only those who are elected by the employees of the bank have power to represent them. As such, recognizing and adhering to the request of office bearers of the unions or associations would be against the Code of Discipline, which amounts to unfair labour practice as defined in Indian Industrial Disputes Act 1947. In short, National Industrial Tribunal is expected to take a decision on the competence and authority of IBA and UFBU in signing settlements on behalf of the bank employees. Under these circumstances, any amount paid to the employees on the basis of such settlement is nothing but an ad hoc or interim payment. It is subject to the outcome of the adjudication proceedings. Further, as per settled law, no amount can be deducted by the bank without the written authorization from the employee concerned. If any bank tries to do so, it will be tantamount to indulging and committing unfair labor practice as defined in the Industrial Disputes Act 1947. In other words, we bankers are asking the banks to abstain from deducting levy from the arrears to be paid to the employees because it will be illegal. In addition to conveying their objection to deduction of levy, we bankers are also asking the banks to pay interest on the arrears proposed to be disbursed to the employees. The funds earmarked by the banks for payment of arrears is nothing but the deferred wages of the employees, which ought to have been paid to them in anticipation of increase in salary. This was not done, and instead the funds were used by banks to make profits. In view of the above, we bankers request the heads of public sector banks not to deduct any amount at the request of the office bearers of the unions without due authorization from the employees concerned as per the law already settled. We bankers also request the banks to release the amount held in reserve for payment of arrears to the employees. The amount should be paid with applicable interest for the duration for which the amount, which in fact is deferred wages, has been kept with the banks. So friends, we bankers who had filed writ petition in Allahabad High Court challenging the authority of IBA in deciding the wages for bank employees and for implementation of separate system like CPC for fixing bankers' salary and allowances are continuing with their legal battles. Thank you.